What to do when a reporter calls you for comment at 5 o'clock on the dot regarding a case that was just filed against your client, but that you haven't even had a chance to review. In this video, I'll tell you. Hi everyone, my name is Wayne Pollock. I am an attorney who helps other attorneys and their clients ethically, strategically, and proactively engage the court of public opinion. In this video, last-minute requests for comment from reporters. It is not uncommon for a defense attorney to receive a call at 5 o'clock on the dot when a reporter is going to publish an article about that attorney's client and a lawsuit that was just filed against that client. And the reporter needs comment from the attorney, or at least is seeking comment from the attorney. This is very frustrating for defense counsel because there's not much you can do. A reporter could very well call you at 5 and say, I'd like a response by 5:15. Well, that gives a defense attorney very little time to dive into the allegations in the complaint against the client, let alone actually speak with the client and come to a consensus about what to say and how to say it. There's really not much that defense counsel could do in a situation like this, but let me give 2 tips that will help any defense attorney get through this difficult situation. So the first is that you should respond if possible. Sometimes attorneys are out and about, sometimes they're just unable to get back to a reporter in time. Fine, I understand that. It stinks, but I understand that. If you are able to get back to a reporter in time, I would suggest that you come up with a response that frames the legal dispute in a certain way, as opposed to trying to provide a substantive response to the allegations. So for example, if your client is involved in some kind of business dispute, I think the better option here is to respond in a way that frames the legal disputes in a way that portrays perhaps the business partner who's suing your client as having sour grapes or being jealous that your client took the business in a new direction, and now that former business partner wants to reap the benefits without actually having done any of the work, or something like that. Frame the dispute. Don't get into the substantive allegations because you don't have time to in this situation. The second tip is to consider whether you need to go back to the reporter after the story has already run. So if you weren't able to respond in time, but you spoke to the client that night and you want to get a statement out to the reporter, then do so even after it's been published. If you were able to get back to a reporter in time and your comment made it to the first edition, the first version of the online story or the print story, but you want to say something better or in a more substantive or more fulsome way, go back to the reporter later that day or the next day and seek to have them update the story. You can absolutely do this. I've done it before. It's not a big deal. The question is whether you have the material, the goods, to go back to update the story with. If you're just adding a comma or you want to change a word, obviously it's not worth it. But if you've got some more things to say, certainly consider going back to the reporter. Now, tip 1 again was go to the reporter, respond to the reporter and frame the dispute. And number 2 was consider whether you need to go back to the reporter a second time, depending on your circumstances. While you're doing this, you have to always keep in mind the ethics of what you're doing. From an attorney ethics perspective, you have to be thinking about defamation. That's always a concern when you're talking publicly about a client's case. But when reporters call you at that 5 o'clock deadline, there's not much you can do, but you should respond. And you should try to make your client's case as often as possible. Just like in a court of law, you wouldn't think twice about skipping an opportunity to respond to the other side's filing or the other side's actions. When it comes to the court of public opinion, you shouldn't think twice either. Even if you don't have the most robust, most well thought out statement. The reason why it's important for defense attorneys to respond, even if they can't respond with as robust or as fulsome of a response as they would like, is because defense attorneys and their clients as defendants so rarely have an opportunity to tell their side of the story outside of court and even in courts. If you think about it, with most litigation, you're not getting a chance to tell the defense side of the story until, what, motion for summary judgment, you might be able to sprinkle some things into an answer or a motion to dismiss, but in terms of the substance, it's rare for defense counsel to get an opportunity to tell their side of the story early in the case. That's why engaging the court of public opinion like this, even where it's not optimal, is important for defense attorney, because they need every opportunity and should take advantage of every opportunity they get to tell their client's stories in the court of public opinion. And responding to a reporter on a short deadline certainly qualifies as such an opportunity.